This Harvard law professor gets it dead wrong. Good morning, good afternoon, or good evening from wherever you're watching or listening. My name is Caleb Glick. I'm a lawyer here in the great state of Texas with the Calhoun School of Law to bring you a lot of information plenty of bad folks would rather you not have. For today's lecture, ladies and gentlemen, we're going to be going through a Harvard law professor's presentation on exactly what you learn in law school. We're going to analyze just how accurate he is and whether or not what you're taught in law school is actually of any value to you as a practicing jurist, as a practicing lawyer. Now, from a recent interview that Mr. or Justice Clarence Thomas had conducted for the University of Texas, it actually made it pretty clear what law schools, modern law schools, go over.
When I was in law school, we didn't even read the Constitution.
Now, he graduated from Yale and not Harvard, but Yale is still one of the Ivy Leagues like Harvard. So what Mr. Thomas says goes on at Yale likely goes on across the board at all of these different law schools, especially when we remind ourselves that every single law school, and I say that generously, virtually all the time with air quotes, virtually every law school in these United States has to first comply with the American Bar Association's curriculum, which we've gone over in the past, but nowhere does it include in that required curriculum anything like studying the Constitution of the states of the U.S., the U.S. Declaration of Independence, the Federalist Papers, Anti-Federalist Papers. All of the information that a lawyer would actually need isn't a required part of the curriculum mandated by the Marxist criminal organization named the American Bar Association. So, without further ado, let's actually jump over to this Harvard law professor and see exactly what he says. We'll critique as we go along, but take it away.
Imagine I asked you, what do you learn in law school? Well, you've decided to take this course, so maybe you're more informed than the average person. So instead, imagine I asked your college roommate or your parents, assuming they're not lawyers. The image that may come to mind of law school is sun-deprived, bespectacled law students surrounded by large numbers of dusty books, reading intently so they can memorize a bunch of law cases. But don't get me wrong, we do make students read a lot from books, and there's some memorization involved. But that image of someone learning the law by just memorizing things that are already out there is not at all what law school is really about. If it were law school,
and he is very right about that, despite that being exactly what it should be about. It shouldn't be about nuance and artistic design. No, the law is written, the law is very simple, the law is self-evident, and the law that lawyers in the Western context are supposed to apply, at least in the framework of the Western context, is explicitly enumerated. Late and great Justice Antonin Scalia spoke directly to this and recited the long-standing Latin legal maxim, inclusio unius est exclusio alterius, which translates to the inclusion of one excludes all others. And this, if there is any sort of core principle to U.S. governance and to the whole idea of the governance of the states at the state level as well, it would be that the powers of government, the properties or the assets that are to be debated and discussed and applied by lawyers are directly enumerated. Anything not explicitly stated isn't a power to apply, to debate, or to be exercised by any sort of government. And that latter is exactly what Mr. Cohen's going to be kind of talking about and alluding to. I don't think he ever says it directly, but that's what he's implying here. That you can't just memorize what's said, you have to go beyond the picture. You have to go beyond what's written, which is a common theme in all of these Marxist American Bar Association law schools. But I digress. Go ahead.
School would be much less fun and also much less useful. The law is always changing. So if you just learned a number of dry rules, much of what you learn might be outdated by your 5th year in practice.
Yes, if you take your time studying the U.S. Constitution, and you take your time studying your state's respective constitution, and all of the Federalist Papers and Anti-Federalist Papers, and you memorize those, and you really involve yourself in the principles contained within those documents, well, by the time you get into the field of law, everything's going to have already changed. So you have to keep nuanced. You have to keep thinking differently because the laws always change. No, the exact opposite is true. The U.S. Constitution, it can change, but only through Article 5 of the U.S. Constitution and the respective articles contained in the state constitutions. No, law, especially the natural law that the founding generation alluded to whenever they wrote up and sent off the U.S. Declaration of Independence, it doesn't change. When you learn that, you are better equipped than most lawyers now. Well, lawyers in air quotes, most lawyers now, and you are getting close to equal footing to what the founding generation thought. They thought, no, laws do not change whimsically, do not change by the time you're out in the field of law. It's supposed to be consistent, and it's supposed to be reliably static. Because natural law, the law that everything else is built upon, does not change. So no, Mr. Cohen, again, you were just dead wrong here.
The chief value of legal education is not to know stuff, but to know what stuff to look for, where to find it, how to interpret what you find, what to think when some stuff says one thing and other stuff says another, and how to use what you find to give legal advice. Let me put this very tangibly for you. If you call up a lawyer on anything other than a very simple question, and without pausing, she quickly gives you a straightforward answer, you should fire her. She's not doing a very good job for you.
Yes, how dare a lawyer be honest? Yes, how dare a lawyer show any sort of concise, direct answer? And maybe that'll start to make sense as to why so many of the politicians kind of circumvent, anybody in politics circumvents giving a direct answer. When we discover that most of the politicians, especially at the U.S. federal level, most of them are lawyers and attorneys, which means they're students of people like this guy who say answering questions directly is a bad thing, is condemnable. So when we connect those two dots, it makes a lot more sense as to why when you ask someone running for office, well, what do you think about this? They say, well, when we consider that, you have to consider all of these other things. No, just answer the question. Answer directly. If you want to bring in all these other factors, fine, but make that an elaboration. Don't give that before the answer.
She's just not thinking like a lawyer. That's a phrase that you'll hear a lot in law school. And while we might overuse it a bit,
No, thinking like a lawyer results in giving direct answers. Why? Because the law is consistent. Why? Because the law, the natural law, is compliant with the idea of the rule of law. And the rule of law requires simplicity, and it requires brevity. Direct, explicit provisions. Otherwise, it gets obfuscated, it gets confused, it gets caught up in all of these different perversions and amalgamations, which ultimately require you to depend upon a class like Mr. Cohen is trying to develop. The founding generation spoke directly to this. Even Alexander Hamilton in Federalist Paper 78 warned about the virtually inevitable despotic end of the judiciary if you allow it to post up or to exalt individuals like this into any sort of authority, any sort of influence in the field of the judiciary, in the field of law.
Does capture something important. Law is mostly about questions, choices, and analysis, about thinking, and not so much about simple answers.
No, legislating is about questions, choices, and what's that last one? Analysis. Legislating is the result of questions, choices, and analysis. Laws have to be direct, and if they're not direct, the founding generation, again, spoke directly to this. If a law is not direct, it cannot be applied. Inclusio unius est exclusio alterius. So if the law is unclear, it's better to nullify it than it is to try to apply it. That was vaguely referenced in the Virginia and Kentucky resolutions of 1798. So this isn't an antiquated idea. It was implemented used at a legislative level as well as a litigatory level by the founding generation. This wasn't a fringe idea. This was the idea. No, again, Mr. Cohen, you are absolutely wrong about the law. Correct about legislation, not about law.
That is the main thing we try to teach you in law school. Yes, we want to teach you a good amount of content about the law. To use an example from a course I teach, Civil Procedure, we want you to know what claims without subject matter jurisdiction can get jurisdiction by way of being joined to other claims through 28 U.S.C. 1367. If that sounds a bit intimidating at first, that's very normal. It is. But by the end of 1L Fall, that knowledge will be at the tip of your brain, or at least somewhere in there. But while this kind of content is important and useful, the main thing we're trying to teach you is a set of approaches, techniques, a disposition to dealing with real problems that will enable you to go out in the world and deal with any legal problem.
All of that was a euphemism for exactly what late and great Justice Antonin Scalia spoke to in a number of his books. What Mr. Cohen said there wasn't to apply the law as it is written, but to apply the law as you think it is written, to be a purposivist, to conduct all of this analysis to find the true meaning and intent behind a law. No, that's all done and handled in the legislature. And if you have a question about the constitutionality, you don't iron it out in a civil or criminal matter. You take the Texas legislature, the state legislature, to the courts. And then you don't provide all of this nuanced analysis. You say, look, here's what the Constitution of this state says. This act from the legislature irrefutably violates that clause or clauses, which means it's not binding. It is not law. It is an overreach, an unconstitutional act. All of what Mr. Cohen said just there was a euphemism of the exact, or a euphemism representing the exact problem that the American Bar Association has mandated and used to pervert the judiciaries of the states and of the U.S. It's the exact problem that late and great Justice Antonin Scalia alluded to on so many different occasions about modern legal education.
Some of these may be problems related to courses you never took. Indeed, some may relate to legal issues that never existed when you went to law school. A lot of my work is on cutting-edge technologies, so I encounter these all the time. Topics like in vitro fertilization and posthumous conception. So a key goal of law school is to make you into a legal Swiss Army knife, to have the tool for any problem you encounter, or at the very least to know where to find that tool. To be clear, that doesn't mean you're to become a hired gun. Instead, you're called upon and valued for your ability to exercise independent judgment on questions of law and on policy. Some of you will want to become trial lawyers. Others will want to go into public service. Others will want to become deal lawyers or go into business through law. Others still will want to work for advocacy organizations. Many of you will disagree about many legal questions, but law school will help you learn to disagree and to argue in ways that are more likely to convince others that you are right. Regardless, we want to enable you to give sound legal advice to your client, or perhaps if you're engaging in cause lawyering, to figure out a legal strategy and find a client who might bring that case. As we will develop in a later segment, while there are many legal skills to learn, from oral advocacy to negotiation, from contract drafting to organizational design, there are 5 primary skills that every lawyer will need to bring to the table. First, digest the facts. Second, spot the relevant issue or issues. Third, determine the governing law. Fourth, apply the governing law to the facts to generate arguments and probabilistic assessments. And finally, work with the client to understand how the legal analysis fits in with the client's overall interests and goals. And
what's so interesting is that was correct, but actually contradicts the earlier statements he was making about analysis and questions and choices. Let me skip back just 1 second there to show you those steps that he discusses. Digest the facts. This is actually an acronym that I see very often and that I personally use whenever I'm drafting up complaints or like a memorandum of law. It's IFRAC, IFRAC, which stands for issues, facts, rules, analysis, and conclusion. You have facts, issues, rules, analysis, and conclusion. But none of that requires anything except memorizing the law. Memorizing exactly what these governing documents, what the governing law is. Now, does that mean you have to have every single statute at the forefront of your mind and be able to recall every single statute on a whim? Obviously not. But it does mean that whenever you find the law, there's no nuance. There's no antiquity. There's only the law. And again, if the law is unclear, founding generations said, if it can't be reliably applied, then it's better to not apply the law at all. So no, you don't need all of this specialty training, all of this expertise training to think like a lawyer. Virtually none of the founding generation went to law school. Yet they practiced as lawyers. And they were able to, in a time significantly more difficult to attain knowledge, especially on the idea of law, were able to generate our founding document, one governing document, and a second governing document. And then, of course, their respective state governing documents. So how is it that the individuals who generated our current governing document didn't need a formal legal education to think like a lawyer, but somehow we do? That doesn't suggest that the law has changed. That suggests that it's been perverted to an extent that would probably be unrecognizable to those very same people who generated our current government. That's what I find so fascinating about Mr. Calhoun, at least in this particular part of his video. These 5 steps contradict what he was saying earlier. Again, you don't need specialties. You don't need specialty training. You have access to a virtually infinite vault of information at your fingertips. Realistically, that is all you need to be a lawyer. Now, of course, having that vault then implies and instills an obligation on you to then go and read about governing documents like the U.S. Constitution, Articles of the Confederation, U.S. Declaration of Independence, Federalist Papers, Anti-Federalist Papers, all of that. But notice he doesn't prioritize those documents at all, or even hints towards reading important primary information such as that. Instead, he focuses on needing to reframe your mind to thinking like a lawyer.
Overall interests and goals. And this whole course is aimed at getting you started on mastering these skills.
Okay, so that was all Mr. Calhoun had to say. So I want to first say, Mr. Calhoun, this is not a harpooning or a chastisement of you as an individual. I know that what you're stating here in this video is nothing more than a regurgitation that you were forced to ingest. Otherwise, you wouldn't get to be a law professor. Otherwise, you wouldn't get to be a lawyer or an attorney or a jurist. I understand that. And the American Bar Association, if there is anyone to blame, is solely to blame for your misunderstanding of what actual law and what being an actual lawyer requires. Again, I want to reiterate, if the founding generation didn't need to do what Mr. Cohen suggests an up-and-coming lawyer has to do today, if they didn't need to do it then to generate the current government we operate under, how does it then naturally follow that we have to follow these steps or obey and implement these steps in order to effectively apply and uphold that government? If the writers of the government didn't need it, why do the appliers of that government need it? Why do the applicators and implementers of that government need it? It doesn't naturally follow. But the reason that mandate is there from the criminal Marxist organization, the American Bar Association, is because without that control, without that mandate that Mr. Cohen had to comply with, otherwise he wouldn't get to practice law, that perverse understanding that Mr. Cohen just regurgitated wouldn't have any chance of surviving in any branch of government, whether that be in the courtroom, whether that be in the executive, whether that be in the legislative. Because what Mr. Cohen is articulating is exactly what the American Bar Association, as frequently discussed by the late and great Justice Antonin Scalia, he depicted a purposivist perspective. Yeah, law isn't just about memorizing stuff. It's also about taking those memories and reorienting them and restructuring them and reframing them. No, that idea is directly contrary to what the actual law, the actual governance, and actual tradition of Western jurisprudence says, denotes, and demands. The entire idea, the whole principle of the government of laws rather than of men depends on a number of principles, but largely depends on one in particular, that being inclusio unius est exclusio alterius. The inclusion of one excludes all others, which means, no, the law is not complicated. No, the law is not confusing. It is simple. It is direct. And if it's not simple and if it's not direct, then it cannot be the law. What Mr. Cohen isn't advocating, or Mr. Cohen is advocating for, isn't that government of laws, the old antiquated stuff that Mr. Cohen said is not all that important. He is advocating for a government of men. That by the time you supposedly leave law school, what you would have learned if you were just memorizing laws would be outdated. That's the result of a government of men, rather than the government of laws that has been implemented and instituted in Western jurisprudence. So, if you have any questions about this topic, maybe you think I'm totally off my rocker and you completely agree with Mr. Cohen, maybe there's a legal topic you'd like me to cover in a future lecture, go ahead and post those down in the comments, because the entire purpose of the Calhoun School of Law is to equip you with the necessary skills and information, such as this, to combat any sort of lawfare that will be waged against you, your loved ones, or your hard-earned property. So please, if you have any questions at all, go ahead and post them down in the comments. Excellent. So my name is Caleb Glick. I'm a lawyer here in the great state of Texas with the Calhoun School of Law to bring you a lot of information that plenty of bad folks would rather you not have. I hope you enjoyed this lecture, and if not, while you're down in the comments, go ahead and let me know how I can do better so I can best serve that purpose of helping you. I hope you'll have a wonderful day, and until I see y'all in the next lecture for the next topic, I bid you all farewell.